Okay, we'll call ourselves back into session. Ms. Medlin.
Thank you, Mr. Chairman. Just as a preliminary matter, I just would like to ask to be excused after today from the remainder of the hearing.
You may.
Okay, thank you very much.
Thank you. I guess you can, but I'm going to overrule you. All right, we've got Mr. Alatorre on stand, and we're ready for cross. Mr. Cleveland, you looked anxious, so I'm ready to let you up there.
Thank you, Mr. Chairman. I promise I'll try and keep it brief. Could I have the Elmo, please? Just waiting for the overhead projector, Mr. Alatorre. My name is Will Cleveland. I'm an attorney with the Southern Environmental Law Center. I'm representing the Coastal Conservation League and the Southern Alliance for Clean Energy. Thank you. Mr. Alatorre, if I could, I'd like to start with your direct testimony at page 7. You testified, and this is lines 14 through 17. I've got the highlighted section. Without proper regulatory oversight and controls, Dominion could exercise control over SCE&G to cause them to participate in future expansions of ACP at a greater cost than similar service on Transco. Do you see that?
Yes.
Is that true?
Yes.
Is that your concern?
That is our concern.
And ACP stands for Atlantic Coast Pipeline?
Yes.
Okay. I want to talk specifically about how the Atlantic Coast Pipeline could produce higher costs for customers. Are you familiar with how FERC approves projects like the Atlantic Coast Pipeline?
No, I'm not in the rates group.
Okay. Do you have any idea of what level of analysis FERC applies to these kinds of projects in terms of how much the market needs these new projects?
I know that there's a needs analysis, but not much more than that.
Do you know whether that needs analysis does anything other than just look at whether the pipeline developer has sold a contract for capacity on that pipeline?
No, I don't know.
Do you know if the analysis does any scrutiny beyond looking at a contract if the pipeline capacity purchaser is affiliated with the pipeline developer?
No.
Okay. Sorry, Mr. Chairman. This is an order on rehearing from FERC on the Atlantic Coast Pipeline dated August 10th of this year. This is on page 19. And FERC says, we disagree and affirm the certificate order's finding that even though all but one of the ACP project shippers are affiliated with Atlantic, the Commission is not required. And it goes over onto the next page. To look behind precedent agreements to evaluate project need. Have you ever read this order?
No.
Okay, so you actually aren't familiar with this process?
No.
Do you know whether any of the FERC commissioners have disagreed with the approval of the Atlantic Coast Pipeline?
I don't know.
This is that same order. This is Commissioner LaFleur, dated August 10th, dissenting. And she says twice, I concluded the project as proposed was not in the public interest. And later down, she says, I still do not find the AC project is in the public interest. Were you aware that Commissioner LaFleur had dissented in this order?
No.
Okay. This is dated that same day. This is a statement from Commissioner Richard Glick of FERC, where he says, I do not believe that the Atlantic Coast Pipeline project has been shown to be in the public interest. Were you aware that he had done that?
No.
Mr. Alatorre, you talked about how the Atlantic Coast Pipeline might increase cost to customers. Could you explain what you meant by that, please?
Yes. So our concern was that if there wasn't a clear process on vetting projects, and with Dominion being part of it, We just wanted to make sure that there was a clear process, that there was an even playing field when there was new capacity or existing capacity.
Thank you. And is it your belief that capacity on Transco is lower cost than capacity on an Atlantic Coast Pipeline expansion would be?
Based on the filed rates of $1.72 or so, our existing capacity is much less expensive in that part of our system.
This is page 8 of your testimony. In line 13, you say the capital cost of constructing ACP involves an investment of $5.07 billion. Is that correct?
Correct.
Do you know whether the costs of the Atlantic Coast Pipeline have gone up since you filed this testimony?
I've read that it's gone up, but don't know specifically how much.
This is the quarterly earnings call that Dominion had on November 1st of this year. And I'll represent to you that on page 7 of the transcript, Mr. Farrell, the Dominion CEO, has said that project cost actions have increased the range of $6 billion to $6.5 billion to a range of $6.5 billion to $7 billion, excluding financing costs. Does that sound about right with what you've heard?
Yes, I did read that.
Do you know whether Dominion shareholders or the pipeline customers are going to absorb that billion-dollar change? I'll put it back up on the screen.
I guess it depends on whether it's a negotiated rate or a recourse rate. I'm not sure. I think they had the option to select either.
Okay. So I'm going to put up on the screen a section from later in that earnings call. This is Mr. Farrell, again, talking about the increase in prices. And the highlighted portion says, we've already been through one process with customers on the rates, and we'll continue to work with them. The returns are going to be very adequate and comments with, which I assume actually is supposed to be commensurate with, the normal returns we get in projects like this. Does this make you think that the shareholders or the customers are going to absorb that cost?
I'm not sure.
Getting back to your testimony, this is page 8, lines 5 through 6. You're talking about the Dominion potential for contract with ACP, and you say this could displace SCE's existing cost-effective firm transportation service through Transco's legacy pipeline facilities with expensive new infrastructure. Do you see that?
Yes.
Do you still agree with that?
Yes.
So in your opinion, is there enough capacity on the Transco system right now to provide reliable service to South Carolina Electric and Gas's current gas-powered generation for the foreseeable future?
With respect to our pipeline, we're fully subscribed. We have no unsubscribed capacity. If there is a need for more capacity, we will have to build facilities.
But SC&G currently has capacity on your network, doesn't it?
Correct.
And are you aware of, do you have any idea whether the amount of capacity they currently have under contract is adequate for their needs?
I don't know.
Okay. On page 10 of your testimony, lines 1 and 2, you say shippers on Transco's system have access to gas supplies from many different supply basins. Is that true?
Yes.
Do you know what Dominion South Point is?
Yes, it's near our Leidy storage fields.
And is it fair to say that the Atlantic Coast Pipeline will be sourcing gas from that location?
Yes, that'll be one area.
And that's in the Marcellus, right?
Yes.
Okay. Gas prices in the Marcellus historically have been lower than in Transco Zone 5. Is that correct?
Yes.
And that's largely because producers have had insufficient pipelines to get their gas to market. Is that fair?
Yes.
And there are a lot of different projects going on in that region, are there not?
Yes.
Are you aware that my witness, Greg Lander, has testified that infrastructure projects in the Marcellus, other than the Atlantic Coast Pipeline, will bring enough takeaway to the region that producers will be able to sell their gas more or less at parity with Zone 5?
I've read that. I don't know if that's true or not.
Are you familiar with the Atlantic Sunrise project?
Yes, we've been involved in it for last couple of years.
This is from October 26th of this year. It's from Natural Gas Intelligence. And the headline is Natural Gas Prices Climb for Cabot as Atlantic Sunrise Unlocks 1.05 billion cubic feet per day. And I've highlighted a section that says, the takeaway capacity has come online through the basin this year, which has helped to lift prices that have long been restrained. Does that square with your understanding of how Atlantic Sunrise and the other current projects have allowed prices in the Marcellus to rise?
With respect to Atlantic Sunrise, prices have risen in the Marcellus area.
So is it fair to say that the price differential between Dominion South Gate and Zone 5 is shrinking?
Yes, on most days.
Okay. Back to your testimony, you say shippers on Transco's systems have access to gas supplies. Do shippers on Transco's system have access to gas supplies from the Marcellus, even if Atlantic Coast Pipeline isn't built?
Yes, we have 1.7 BCF of ASR capacity now, and then we have existing supply from Marcellus that's on our Leidy line.
So to the extent that somebody wants gas from the Marcellus, they can use your system to get it without having to ever have the Atlantic Coast Pipeline built. Is that fair?
If they have firm capacity, yes.
And I think you also just said this, but I just want to make sure we're clear. And the Marcellus gas is less and less cheap relative to Transco Zone 5?
Transco Zone 5 is the most expensive area, along with New York City. It's not at that level, but it is closer.
It is closer. Did you read Mr. Lander's testimony in this case?
Very briefly.
Do you remember where he said that he's looked at Dominion's own internal gas price forecasts, and those forecasts show Dominion Southgate converging with Zone 5 in the future?
No, I didn't read that piece.
Turn now to your recommendations in your testimony, please. Because you're here to support the settlement, is that correct?
Correct.
Yeah. I'm going to turn to Exhibit HA2 of your direct testimony, if I could. This is bullet 3. And you said that Dominion shall not, this is a recommendation from the company, is that correct? From Transco, is that correct?
Correct.
Okay. So bullet 3 is that Dominion shall not construct nor otherwise acquire any new natural gas transmission facilities for the purpose of serving gas-fired electric power generation plants or local distribution company loads owned or operated by SCANA or an affiliate without obtaining prior approval from the Commission. You see that?
Yes.
And do you think that was a good recommendation?
Yes.
Now put the settlement agreement up on the board, or on the screen, if I could. And there are really two paragraphs in this settlement agreement that have to do with SCENG's acquisition of capacity. Is that fair?
Yes.
So bullet 1 says that they won't acquire any new capacity without an RFP for over 100,000 decatherms per day. Is that fair?
Yes.
And bullet 2 says that they shall not sign any contracts unless it is either 1, the least cost provider of such capacity, or 2, unless the Commission has approved the contract. Is that fair?
Yes.
Does the settlement agreement have any provisions for what the RFP looks like?
No.
Does the settlement agreement have any provisions for what the RFP screening criteria look like?
No, just what's on there.
Would you agree that an RFP's results are only as good as the RFP itself?
Yes. Yes.
And this settlement agreement doesn't provide this Commission with any oversight of that RFP process, does it?
No.
Okay. And so in bullet 2, if that RFP identifies something as least cost, under this settlement agreement, the company can sign that contract without Commission approval. Is that correct?
Correct.
So there's no oversight or review of the RFP. There's no oversight or review of the RFP's terms. And if that RFP identifies something, the company can sign it without any oversight from this Commission. Is that fair?
From our standpoint, we just want access to an RFP and the least cost provider, and then there's flexibility in for the commission to be able to rule if there's something different that they want to.
And I understand that. I understand that your company is happy with the settlement, but I just want to make sure I'm clear. There's no RFP oversight by this commission. There's no RFP screening criteria oversight by this commission. And if the RFP identifies something as least cost, there's no oversight by this commission on the company's ability to sign that contract?
Now, the request for proposal, it just asks for a good faith.
Thank you. My client is particularly concerned, as your client was earlier, that there might be the potential for some affiliate contract abuses that would justify an unnecessary and very expensive expansion of the Atlantic Coast Pipeline. Were this commission to adopt an additional requirement that all affiliate contracts with relating to natural gas capacity get adopted and required for prior approval before they can be signed, would Transco oppose that?
We're happy with this settlement, and that's really not our area.
Okay, thank you. No further questions, Mr. Chairman.
Thank you. Other cross for Mr. Alatorre. Commissioners? Mr. Griffith, any redirect?
No redirect, Mr. Chairman, and we'd like for Mr. Alatorre to be excused.
Thank you, Mr. Alatorre. Thank you for your testimony, your time and travel, and you are excused. Thank you. Okay. Company, next panel.
Mr. Chairman, SCE&G will call Dr. Ken Petrunick, Kevin Kokums, and Kyle Young. While they're coming to this table, we wanted to update the commission and Mr. Butler on the use of depositions. We've had some discussions with the Office of Regulatory staff on this, and I know you, Mr. Butler, had suggested that we advise everyone as to where we are on the use of depositions by this afternoon. We, at present, believe that the only depositions that will be presented are for witnesses who reside outside the state of South Carolina. So that will be Ty Troutman, the Bechtel Power Corporation representative, various representatives of Westinghouse, and then Ron Jones, who is a former SCE&G employee. What we propose to do, and Matthew and Jim can correct me if any of this is incorrect, but we would submit the entirety of those transcripts with exhibits and the videotapes for those depositions into the record. We would also have a process for designations and counter-designations to the extent that the commissioners wanted to review only what we believe to be the relevant portions of those transcripts. I think it would be appropriate for the ORS to do the designations in the front end, and then we'll do a counter-designation to that. And we can talk about what time is necessary for that. But that would be all of the depositions presented, that the only other testimony before the commission would be live testimony. And at this point, we think the only additional live testimony that the commission should hear is that of this panel and the witnesses that are scheduled for Tuesday or Wednesday of this week, so that there would be no need for further proceedings into the following week. Is that all correct, Matthew?
Yes, and Mr. Chairman, if I might clarify, the two of the witnesses tomorrow, as you know, Ms. Walker and Mr. Brown will be adopting their depositions as if given from the stand. So that's additional use of the deposition testimony, and only one request of a change in that procedure is that we are not offering Mr. Ron Jones at all, and so we would ask them to designate first.
Happy to do that. And then I should note that Mr. Byrne will be doing a similar procedure. Rather than engaging in a direct examination, we'll have Mr. Byrne provide a summary of his testimony and then offer his deposition transcript for his pre-file testimony.
Okay. Very good.
So we'll do this. I'll start here. Just for the court reporter's benefit, we have Kevin Kokums closest to me, Kyle Young in the middle, and Dr. Ken Petrunik. We may have had placards at some point. We will find them if we can and supplement the table with them. But hopefully that will be sufficient for present purposes.
Make sure everybody gets close to your mic when you're speaking.
Okay, Mr. Kokums, let's start with you. Mr. Kokums, can you please state your name for the record?
Yes, it's Kevin Kokums.
By whom are you employed and in what capacity?
I am an employee of SCANA Services, and I'm the manager of regulatory affairs.
Okay. Did you prepare or cause to be prepared under your direct supervision 51 pages of direct testimony dated August 3, 2018, which was pre-filed with the Commission and docket number 2017-370E?
Yes,
Do you have any changes or additions to your pre-filed direct testimony?
I do not.
If I asked you all of the questions contained in your pre-filed direct testimony here today, would your answers to those questions be the same?
They would.
Mr. Chairman, at this time I move that the pre-filed direct testimony of Kevin Kokums in docket number 2017-370E be read into the record as if given orally from the stand.
Mr. Kokums' pre-filed direct testimony in 2017-370E will be entered into the record as if given orally from the stand.
Mr. Kokums, have you also submitted 6 exhibits to your direct testimony labeled KRK1 through KRK6?
Yes.
Do you have any changes or additions to these exhibits?
No.
Mr. Chairman, I move that these exhibits be entered into the record as the next composite hearing exhibit, and those are exhibits KRK1 through KRK6.
Mr. Kokums' exhibits KRK 1 through 6 will be entered into the record as exhibit number 141.
Mr. Kokums, did you also prepare or cause to be prepared under your direct supervision 3 pages of direct testimony dated September 24, 2018, which was pre-filed with the Commission in docket numbers 2017-2007E and 2017-305E?
Yes.
Do you have any changes or additions to your pre-filed direct testimony for these dockets?
No.
If I asked you all the questions contained in your pre-filed direct testimony from those 2 dockets here today, would your answers to those questions be the same?
They would.
Mr. Chairman, I move that the pre-filed direct testimony of Kevin Kokums in docket numbers 2017-207E and 2017-305E be read into the record as if given orally from the stand.
Mr. Kokums' pre-filed direct in testimony in 2017-207E and 2017-305E will be entered into the record as if given orally from the stand.
Thank you. Mr. Kokums, did you also attach to your direct testimony in docket numbers 2017-207E and 2017-305E 7 exhibits labeled KRK 1A through KRK 7A?
Yes.
Do you have any changes or additions to these exhibits?
No.
Okay, Mr. Chairman, I'll move into the record as the next composite hearing exhibits KRK 1A through KRK 7A that were attached to Mr. Kokums' pre-filed direct testimony in docket numbers 2017-207E and 2017-305E.
Okay, those exhibits, KRK 1A through 7A, will be entered as exhibit number 142.
Thank you. Mr. Kokums, did you prepare or cause to be prepared under your direct supervision 7 pages of rebuttal testimony dated October 24, 2018, which was pre-filed with the Commission and docket number 2017-370E?
Yes.
Do you have any changes or additions to your pre-filed rebuttal testimony?
No.
If I asked you all the questions contained in your pre-filed rebuttal testimony here today, would your answers to those questions be the same?
Yes.
So, Mr. Chairman, I'll move that the pre-filed rebuttal testimony of Kevin Kokums in docket number 2017-370E be read into the record as if given orally from the stand.
Mr. Kokums' pre-filed rebuttal testimony will be read into the record as if given orally from the stand.
Mr. Kokums, did you also prepare or cause to be prepared under your direct supervision 2 pages of rebuttal testimony dated October 29, 2018, which was pre-filed with the Commission and docket numbers 2017-207E and 2017-305E?
Yes.
Do you have any changes or additions to your pre-filed rebuttal testimony?
No.
If I asked you all the questions contained in your pre-filed sir rebuttal testimony here today, would your answers to those questions be the same?
Yes.
Mr. Chairman, I move that the pre-filed sir rebuttal testimony of Kevin Cocombs be read into the record as if given orally from the stand.
Mr. Cocombs' pre-filed sir rebuttal testimony will be entered into the record as though given orally from the stand.
Did you submit with your sir rebuttal testimony one exhibit labeled KRK1?
Yes.
Do you have any changes or additions to that exhibit?
No.
So, Mr. Chairman, I move into the record as the next composite hearing exhibit, exhibit KRK1, that was attached to Mr. Cocombs' pre-filed sir rebuttal testimony.
Exhibit KRK1 that was attached to Mr. Cocombs' pre-filed sir rebuttal testimony will be entered into the record as Exhibit 143.
Mr. Cocombs, have you prepared a summary of your testimony in these proceedings?
I have.
Can you please deliver it?
Good afternoon, Chairman Randall and members of the Commission. The purpose of my testimony is to present the schedule of costs for the N&D project as it stands after abandonment. The costs are set forth in exhibit number KRK-1, which is an updated schedule of the capital costs associated with the project that were incurred as of December 31st, 2017, net of costs associated with those aspects of the project that are being or have been placed in service. SCE&G is requesting the Commission adopt KRK-1 as the updated and approved capital cost schedule for the project as of December 31st, 2017. SCE&G further requests the Commission find that the cost schedule is a reasonable and prudent schedule of capital costs and that SCE&G is legally entitled to amortize and recover these amounts through rates. All of the costs included in KRK-1 are actual capital costs that were incurred on or before December 31st, 2017. As noted on KRK-1, adjustments may be made to increase or decrease the capital cost as pre-abandonment and abandonment transactions are finalized. The costs set forth in KRK-1 fall well within the scope of cost projections that had been previously approved by the Commission as the reasonable and prudent cost schedules for the project. Furthermore, the majority of the costs reflected in KRK-1, specifically those incurred before June 30th, 2016, were reviewed and audited by the South Carolina Office of Regulatory Staff, ORS, as historical costs in revised rates proceedings. Therefore, the costs have already been determined by both the Commission and ORS to be reasonable and prudent. The company requested authorization to revise the capital cost schedules for the project as those cost schedules evolved over the course of the project. The requests were made on 5 occasions in docket number 2009-293E, 2010-376E, 2012-203E, 2015-103E, and 2016-223E. In each case, with certain adjustments proposed by the ORS, the Commission conducted a contested hearing case, approved the revised rate schedule, and determined that the adjustments were reasonable and prudent. The orders approving these updates are orders number 2010-12, 2011-345, 2012-884, 2015-661, and 2016-794. Under the capital cost schedules adopted by the Commission in Order 2016-794, total spending on the project was approved up to $7.7 billion, and the amount approved to be spent by December 31st, 2017 was $6 billion. The actual amount cumulative spent as of December 31st, 2017 was $5.1 billion, including the cost of transmission projects and other projects that have been or are being placed in service. Therefore, the spending on the project is fully consistent with the amounts approved in prior dockets and the amounts listed on KRK-1. Particularly since the schedule is net of transmission projects and other projects that are being or have been placed in service. The amounts, therefore, are subject to prior prudency decisions made in the BLA orders listed above. The costs reflected in KRK-1 have been audited and reviewed in prior rates proceedings. There have been 9 revised rates proceeding and 9 orders authorizing revised rates for the project, beginning with order number 2009-104A. In all 9 cases, ORS performed a detailed audit of SCE&G's actual project expenditures up to June of the year in question. ORS identified any amounts they determined not to be reasonable and prudent capital costs of the project, which amounts were minimal, and issued a report to the Commission verifying the amounts of expended costs that were prudently incurred and appropriate for recognition under the BLRA. In all 9 proceedings, the Commission accepted ORS's report and adopted ORS's conclusion as to the reasonableness and prudency of the costs that ORS had verified. No interested party ever sought a hearing or other review of these determinations. The ORS also conducted ongoing audits of construction costs and internal controls. Throughout the course of the project, ORS conducted ongoing and thorough auditing of project expenses. ORS personnel maintained an office at the construction site, and ORS audit personnel performed their testing from their or their home office location. Auditing of the project was extensive and continuously done on a monthly basis. Over the 9 years of auditing expenditures for the N&D project, ORS auditors confirmed that nearly all costs charged to the project were reasonable, prudent, and appropriate costs of the project. Out of the total of $3.8 billion in project expenditures that ORS audited, approximately $12,000 was disallowed. In short, KRK-1 provides an accurate accounting of the reasonable, prudent, and appropriate plant costs up to and through the company's decision to abandon the project. These are the costs that SC&G should be allowed to recover. I also offer rebuttal testimony in response to certain assertions made by the ORS related to accounting and commercial matters. Among other things, ORS is mistaken when it asserts that SC&G has not agreed to seek recovery amounts for adjustments to expenses incurred prior to December 30th, 2017. It has always been SC&G's position that while it would expense new cost items incurred in connection with the wind down and demobilization of the N&D project after September 30th, 2017, it would continue to recognize adjustments to costs incurred prior to that date. This is a matter of particular importance because the South Carolina Department of Revenue has asserted a claim of sales tax associated with purchases that were made prior to September 30th, 2017. If those claims are upheld, the resulting cost would be deemed to have been incurred prior to December 30th, 2017, when the purchases and sales at issue occurred. If the taxes were collected, they would constitute a governmentally imposed tax and would constitute valid capital costs of the N&D project, which should be subject to recovery through rates. ORS further argues that $42,873 in fraudulent activities should be deducted from the N&D project investment. The adjustments arise from a bid rigging scheme that SC&G uncovered for office furniture purposes for which SC&G was invoiced by CB&I. SCANA's Audit Services Group investigated and determined that the winning bidder had improperly submitted the competitive bids, which allowed the bidder to bid prices that were above market price. Based on that investigation, SC&G refused certain payments to the vendor in question. The claims in question and their resolution were reviewed and audited by ORS and ultimately were included in a settlement agreement in which ORS agreed that the 2015 amendment to the EPC contract and the modified cost schedules that resulted from it should be accepted and approved by the Commission as a fair, reasonable, and full resolution of the issues. This $42,873 was part of that resolution of claims. No further action regarding it is warranted. ORS next indicates that outstanding liens against the project should not be paid out of the Toshiba corporate guarantee settlement payment. When SC&G negotiated the amount of the guarantee settlement with Toshiba after Westinghouse's breach and rejection of the EPC contract, one major component of the calculation was a claim of the value of the liens, which were specifically excluded from the calculation of the liability limitation associated with the guarantee and are one part of the reason that the guaranteed payment significantly exceeds the liability limitation. For that reason, SC&G has consistently asserted that proceeds received from Toshiba should be used to repay the liens because that was the intent and purpose of that part of the corporate guarantee payment. SC&G continues to contest these liens and expect that some of them may be settled by the bankruptcy estate of Westinghouse as it emerges from bankruptcy. SC&G believes that it's entirely appropriate to pay any lien payments be applied against the Toshiba settlement proceeds and determine the net value of those proceeds to be provided to customers. To treat lien payments otherwise would be contrary to the nature and basis of the corporate guarantee payment. In conclusion, I respectfully request the Commission recognize that SC&G has not stated that it will forego recovery of adjustments to costs incurred prior to September 30th, 2017, and that such adjustments are entirely appropriate. SCG also requests that the Commission recognize that it is appropriate for SCG to pay outstanding liens associated with the NND project out of the proceeds of the Toshiba corporate guarantee payment, since those funds were received and intended in part to cover those liens. In addition, SCG requests that the Commission adopt Exhibit Number KRK-1 as the updated and approved capital cost schedule for the project. This concludes my summary.
Thank you. Mr. Young, can you please state your name for the record?
My name is Kyle Young.
By whom are you employed and in what capacity?
I'm employed by South Carolina Electric and Gas, and I'm the manager of nuclear plant demobilization.
Mr. Young, did you prepare or cause to be prepared under your direct supervision 50 pages of direct testimony dated August 3, 2018, which was pre-filed with the Commission in docket number 2017-370E?
I did.
Do you have any changes or additions to your pre-filed direct testimony?
Yes, I have a few changes to this testimony.
Can you please describe them from the Commission when you're ready?
Yes. If you'd please turn to page 39. On line 6, please strike the words 1 unit has and replace with 2 units have. The next correction is on page 44, line 17. Strike the word rents, replace with the word rented. Strike the words are currently and replace with the words were. On line 18, strike the word being. On line 19, strike the word expires and replace with the word expired. On line 20, strike the words expires on November 30th and replace with the words was terminated on August 31st. On page 45, line 2, strike the words will remove and replace with removed. Strike the words terminate and replace with the word terminated. On line 8, add the words 3 of between the words has and 15. And then on line 9, add the word still between the words are and in. And then strike the phrasing as well as an NPDES discharge permit. And then continuing on line 10, an air quality batch plant permit, Norfolk Southern access permit. End strike. Then the last change is on line 15. Strike the words or third party in the case of Norfolk Southern. That ends the corrections or additions.
Thank you. So, Mr. Chairman, at this time I move that the pre-filed direct testimony of Kyle Young in docket number 2017-370E as edited here today be read into the record as if given orally from the stand.
Mr. Young's pre-filed direct testimony in 2017-370E as corrected today will be entered into the record as though given orally from the stand.
Thank you. Mr. Young, did you also prepare or cause to be prepared under your supervision 2 pages of direct testimony dated September 24, 2018, which was pre-filed with the Commission in docket numbers 2017-207E and 2017-305E?
Yes.
Do you have any changes or additions to your pre-filed direct testimony for these dockets?
No.
So if I asked you all the questions contained in your pre-filed direct testimony from these 2 dockets here today, would your answers to those questions be the same?
Yes, they would.
So, Mr. Chairman, I'll move that the pre-filed direct testimony of Kyle Young in docket numbers 2017-207E and 2017-305E be read into the record as if given orally from the stand.
Mr. Young's pre-filed direct testimony in 2017-207E and 2017-305E will be entered into the record as though given orally from the stand.
I apologize to do this, Mr. Young, but I think I forgot to ask you a question on the corrected testimony. So I think it's for the record's benefit. If I asked you all of the questions contained in your pre-filed direct testimony in docket number 2017-370E, if I asked you those questions today, would your answers to those questions be the same?
They would, with those corrections included.
Thank you. All right. Now, Did you also attach to your direct testimony in docket numbers 2017-207E and 2017-305E one exhibit, which was labeled KMY-1A?
Yes.
Do you have any changes or additions to that exhibit?
They would be the same changes that I went over earlier in my direct testimony.
So, Mr. Chairman, I move into the record as the next hearing exhibit, Exhibit KMY-1A, that was attached to Mr. Young's pre-filed direct testimony in docket numbers 2017-207E and 2017-305E.
Okay, the exhibits KMY-1A filed in dockets 2017-207E and 2017-305E will be entered as exhibit number 144.
Mr. Young, did you prepare or cause to be prepared under your direct supervision 5 pages of rebuttal testimony dated October 24, 2018, which was pre-filed with the Commission in docket number 2017-370E?
Yes.
Do you have any changes or additions to your pre-filed rebuttal testimony?
No.
If I asked you all the questions contained in your pre-filed rebuttal testimony here today, would your answers to those questions be the same?
Yes, they would.
So, Mr. Chairman, I'll move that the pre-filed rebuttal testimony of Kyle Young in docket number 2017-370E be read into the record as if given orally from the stand.
Mr. Young's pre-filed rebuttal testimony in 2017-370E will be read into the record as though given orally from the stand.
Thank you. Did you also prepare or cause to be prepared under your direct supervision 1 page of rebuttal testimony dated October 29, 2018, which was pre-filed with the Commission in docket numbers 2017-207E and 2017-305E?
Yes.
Do you have any changes or additions to your pre-filed rebuttal testimony?
No.
So if I asked you all the questions contained in your pre-filed rebuttal testimony here today, would your answers to those questions be the same?
Yes, they would.
Thank you. So, Mr. Chairman, I'll move that the pre-filed rebuttal testimony of Kyle Young be read into the record as if given orally from the stand.
Mr. Young's pre-filed rebuttal testimony will be entered into the record as though given orally from the stand.
And Mr. Young, did you submit with your rebuttal testimony 1 exhibit, which was labeled KMY-1?
Yes.
Do you have any changes or additions to that exhibit?
No.
So, Mr. Chairman, I'll move into the record as the next hearing exhibit, Exhibit KMY-1, is attached to Mr. Young's pre-filed rebuttal testimony in docket numbers 2017-207E and 2017-305E.
Mr. Young's Exhibit KMY-1 attached to his rebuttal testimony will be entered into the record as hearing Exhibit 145.
Mr. Young, have you prepared a summary of your testimony in these proceedings?
I have.
Can you please deliver that?
Good afternoon, Chairman Randall and members of the Commission. I appreciate your flexibility in allowing me to appear here today at this time due to my recent family events. I'm here to testify regarding the status of construction during the time immediately preceding SCENG's decision to abandon the project, the company's analysis of whether to abandon the project following Westinghouse's bankruptcy, the abandonment activities that followed, and the current status of the site. I'm also here to address some issues raised in these proceedings with respect to the challenges the NND team faced in constructing the 2 nuclear reactor units, the actions the NND team took to mitigate those issues, and regulatory oversight of the NND project, specifically the ORS. I want to start with the events surrounding SCENG's decision to abandon the project. Up until December 2016, we had every reason to believe that Westinghouse was fully committed to finishing the project. Westinghouse repeatedly shared with us their goal of becoming the global supplier of advanced passive safety nuclear generation technology. Successfully completing the VC Summer units was critical to Westinghouse's global business strategy. Immediately after Westinghouse filed for bankruptcy in March 2017, I was put on a team tasked with receiving and evaluating Westinghouse's cost and schedule estimate to complete the project, or ETC. At that time, the owners gained access to information that we were unable to obtain previously under the EPC contract because Westinghouse considered that information proprietary commercial data that prior to bankruptcy, Westinghouse would not disclose. After evaluating Westinghouse's ETC, we determined it was insufficient for use by the owners going forward. We were then tasked with independently compiling and verifying an owner's ETC to include a cost estimate and a construction schedule for completing the units as an owner-directed project. Construction continued while the company's evaluation was underway for a number of reasons, including the fact that Westinghouse indicated that the cost for the owners to complete the units as owner-directed projects would be manageable. As we evaluated the information Westinghouse provided after bankruptcy, however, it became clear that Westinghouse was relying on vastly different assumptions than the owner should make. Those assumptions may have been appropriate for a constructor-led project by a company committed to building more AP1000s, but they were not appropriate for an owner-led project at VC Summer. After several months of work, we presented our initial analysis of cost and schedule to the executives of SCANA and Santee Cooper. At that time, there were still viable options for completing construction. The subsequent economic analysis described by Dr. Lynch in his testimony showed that it would still be in customers' economic interest to complete Unit 2 and Unit 3. Completing only Unit 2 with Santee Cooper as a co-owner was also shown to be reasonable. When Santee Cooper announced its decision to suspend the project due to its lack of need for power generation, the decision to abandon was made. Once the abandonment decision was made, we were instructed to put the site in a safe and stable condition, remove and dispose of hazardous substances, supervise the removal of the contractor's rental property, but otherwise take no action inconsistent with the abandonment of the project as of year-end 2017. SCE&G will place in service a number of construction projects that were undertaken as part of the NND project, but will be used to support generation activities at the VC Summer site. These aspects of the project have not been abandoned and are being placed in service. In light of ORS's position that SCE&G should not be allowed to recover costs incurred after the company's March 12, 2015 filing under docket number 2015-103-E, I addressed the challenges the owners faced in constructing the project, including the poor productivity that plagued the project, ORS's regulatory oversight regarding these challenges. My testimony also addresses the contention made by Mr. Gary Jones that SCE&G presented unsubstantiated and misleading estimates of the revised project construction schedule, and then SCE&G did not engage in a good faith effort to provide a properly vetted and documented construction schedule in its March 12, 2015 filing. At the time of the company's 2015 filing, the project had faced various issues causing delay. In particular, this project and the Vogtle project in Georgia were the first nuclear projects constructed under the new NRC licensing structure contained in 10 CFR Part 52. This meant that the project presented many unique challenges. Some of these challenges included licensing, fabrication, design finalization, and recruiting a workforce able to meet strict nuclear safety regulations. By 2016, most of these unique or first-of-a-kind challenges have been overcome or largely mitigated. In particular, module and submodule production issues have been a focus area that SCE&G had identified and addressed continuously since 2010. And by 2016, issues related to the fabrication of structural modules had either been resolved or being addressed with various measures that those involved, including the owners and regulators like the NRC and ORS, believed to be reasonable and good faith attempts that likely address any remaining concerns. As a result of some of the early issues causing delays in the schedule, the consortium of Westinghouse and CB&I began a full rebaselining of the project schedule in the fourth quarter of 2013 and informed the owners that they would be providing them an updated schedule and estimate of the cost to complete the project by the third quarter of 2014. I was involved in the work performed by the owners beginning in the third quarter of 2014 to review the draft construction schedules and cost estimates presented by the consortium. Separate teams were constituted to review the schedule and cost. And while I dedicated more time to the schedule review, I was a liaison with the team that also evaluated the cost estimates the consortium provided. Both efforts were undertaken diligently and in good faith, involving many experienced and dedicated professionals. Specifically, with respect to the construction schedule, the consortium presented SCE&G with several different options or scenarios for substantial completion dates of the units. SCE&G established a schedule-focused team to review these schedule options presented by the consortium. SCE&G's team included representatives from various NND departments: business and finance, construction, design engineering, licensing, and startup. The SCE&G team gathered with the consortium team in a workshop-like setting and reviewed the live schedule from the consortium scheduling database. The consortium answered SCE&G's questions regarding their assumptions, demonstrated the logical ties in the schedule, and showed the ties between the construction schedule and the engineering, procurement, and other integrated portions of the schedule. The consortium also showed where a constraint had been placed in the schedule and typically generated a corresponding schedule risk item. This effort generated the consortium schedule risk register, which addressed known and identified constraints in the schedule with quantified schedule duration risks. The risk register included generation of mitigation plans for major risks. This initial review took place over a month. Subsequently, there are follow-up sessions on specific topics that continued through early 2015. By early 2015, the consortium determined that some of the schedule options that we reviewed were no longer viable and took them off the table during the ongoing negotiations with the owners. In the first quarter of 2015, following this detailed review process and while still negotiating with the owners, the consortium formally communicated to the owner their revised, integrated EPC schedule with target substantial completion dates of June 19, 2019, Unit 2, and June 16, 2020, Unit 3. SCE&G accepted these dates as target dates for the project to work toward, concluding that they were the most realistic of the schedules that have been reviewed since August 2014. At the time of the March 2015 filing, the most difficult risk factor to overcome at the project at that point had been issues with on-site construction productivity. With respect to the nuclear island and turbine buildings, the consortium had been consistently unable to meet the productivity factors on which their cost and schedule estimates had been based. During the course of the project, I observed SCE&G management consistently giving feedback to the consortium management on their poor productivity performance. Project actions were generated that recognized the need to improve productivity. SCE&G also provided observations to the consortium of the issues causing delay. When it became clear that the consortium was not making significant progress in resolving productivity issues, the owners began disputing portions of invoices believed to be caused by poor productivity or delay. Then, in 2015, the owners were able to substantially mitigate the issues caused by poor productivity on site when they negotiated the fixed price option in the October 2015 amendment to the EPC contract. Shortly after the March 2015 filing, Westinghouse approached the owners about its desire to end the consortium structure and allow CB&I to exit the project. This event allowed the owners to negotiate the amendment to the EPC contract that was executed in October 2015. The October 2015 amendment to the EPC contract was significant for the project for many reasons. Most notably, it terminated the consortium structure, included an option to fix the price of the EPC contract, and resolve the existing disputes between the owners and Westinghouse. The NND team welcomed the idea of ending the consortium structure and allowing CB&I to exit the project because it left Westinghouse with the sole responsibility for construction and allowed them to bring in Fluor Corporation as its construction subcontractor. My team and I were cautiously optimistic that Fluor Corporation will be taking responsibility for day-to-day operations. Fluor immediately began work off-site in late 2015 to aid Westinghouse in their transition process, and it began identifying issues that were driving construction inefficiency and poor labor productivity. I was a member of the SCE&G team that was assigned to work with Fluor in conducting a deep dive into the problems hindering efficiency and formulated action plans to correct them. With the benefit of adding Fluor's energy and expertise to the project, and Westinghouse's commitment to take sole responsibility for the project execution, I believe that the problems with construction productivity and other issues with the project could be overcome. As I mentioned, the EPC amendment also gave SCE&G the option to fix the price for completion of the remaining scopes of work under the EPC contract at $3.345 billion. This shifted the costs associated with labor productivity to Westinghouse, dramatically reduced SCE&G's exposure to price risks, and was an important part of how SCE&G responded to the labor productivity issue on site. In short, fixing the price of the contract meant that Westinghouse would be motivated to improve productivity because it would be responsible for any increased costs if labor productivity did not improve. This change in the EPC contract was coupled with large positive incentives and significant negative penalties for Westinghouse to ensure that the project completed on time. All told, while there were important issues yet to be resolved, the EPC amendment alleviated many of the concerns of the project. The company believed, as did I, that the problems with the construction productivity and other issues could be overcome, and that Westinghouse, with the help of Fluor, could improve and finish the project. I am not aware of any design, construction, or technical reason why the units could not have been completed, with commitment and perseverance by all parties. Had that bankruptcy not occurred, Westinghouse would still have the primary risk of completing the project, and we would be working toward doing so for the benefit of our customers. I want to end with a brief overview of the regulators involved in the project, and specifically the ORS. The project was closely regulated by multiple state and federal regulatory agencies, primarily in the areas of safety, quality, schedule, and cost. As I've described in my testimony, the regulatory agencies concerned with safety and quality included the NRC, DHEC, FERC, and the U.S. Army Corps of Engineers. The regulatory agency principally involved with ongoing oversight of the project schedule and cost was ORS. ORS personnel, along with its outside experts, were routinely present on site and in meetings with N&D department managers and other lead personnel from the site for briefings on the current progress and status of the project. ORS was provided with a detailed level of information concerning the status of the project. For example, ORS reviewed the same monthly and weekly construction reports that the consortium provided to SCE&G, which included monthly productivity factors. SCE&G also briefed ORS on upcoming construction and equipment fabrication milestones, any issues or problems related to those milestones, issues or problems related with construction generally, or issues or problems related to equipment or module fabrication. In addition, SCE&G personnel identified and discussed SCE&G's list of focus areas for the project. Focus areas are the areas where challenges had been encountered that were serious enough to pose an important risk to the overall success of the project. Focus areas receive management and project team oversight attention and resources at the highest level. During meetings with SCE&G, ORS representatives requested any documentation they wanted to review, in addition to the monthly, quarterly, and other reports and minutes of site reporting meetings that were routinely provided to ORS. I and other SCE&G personnel responded to ORS's particular requests for information, and my team supplied information as requested. This concludes my summary.
Thank you, Mr. Young. Now, Dr. Petrunik, can you please state your name for the record?
Kenneth Petrunik.
By whom are you employed and in what capacity, Dr. Petrunik?
I'm self-employed.
Okay. What's your educational background?
I have a PhD in engineering.
Okay. Where did you get that PhD?
I was from the University of Windsor, Ontario, Canada.
Okay. When did you receive that degree?
1973.
Okay. And what's the specialty area for your PhD?
My specialty was thermohydraulics in nuclear reactor cores in two-phase flow.
Do you have experience in the nuclear construction industry?
Since 1978, I've been involved in management of nuclear power new build projects, starting with the 4-unit Darlington station in Canada, moving on then to Unit 1 in Romania, moving then to Argentina for a new build project, moving to Korea for extended period to manage those projects, moving to China to lead those projects from the site. And finally, after I retired in 2009 from Atomic Energy of Canada, I took a job 4 months later with the government of the UAE to oversee, as an owner this time, not as a vendor, the delivery of 4 Korean APR 1400 units. So all of my career has been spent in new build nuclear power.
Okay. How many nuclear construction facilities have you successfully completed?
I've been directly involved in the successful completion. Well, the ones in the UAE are not finished, I have to say so, but if you count the number of units I've been involved in, it's about 13.
Are you familiar with Westinghouse and its AP1000 reactor design?
I'm familiar with the Westinghouse AP1000 reactor. I did some work for Westinghouse, as an advisor to them on the bid they were putting together in India, on setting up the project management structure that they were proposing for Moorside, and also reviewing how Westinghouse were managing their overall projects. I knew Jeff Benjamin, who was closely involved and a leader in Westinghouse in all of its nuclear international business.
Okay. So have you been involved in the construction of other AP1000 reactors other than VC Summer?
I visited the Sanmen site several times. Once I took the owner in the UAE there, and I've also visited the site on my own, recognizant. The project director or head of the Sanmen site was one of the senior staff in China who worked for me, and therefore we kept in touch about the status of the project and the issues that were involved. In addition, as part of my work with WEC in the red team that reviewed the India job, I got to meet one of the senior project managers from Summer. I'm sorry I don't have his name now, it's quite a few years ago. And I talked to him about, because of the red team, was WEC ready to do business? And we talked about the modules, we talked about design constructability, we talked about supply, demand, and material, we talked about a number of factors. And I'm a project director, I've worked from the site, and I felt comfortable that he understood the challenges. I mean, it was difficult, but he was committed and the WEC team was committed to get it done.
Thank you. Mr. Chairman, we're going to tender Dr. Petrunik as an expert in this case, but I will walk through the pre-filed direct testimony that he submitted so that we make that clear for the record. Okay. So, Dr. Petrunik, thank you. Did you prepare or cause to be prepared under your supervision 26 pages of direct testimony dated September 24, 2018, which was pre-filed with the Commission in docket numbers 2017-207E and 2017-305E?
Yes, I did.
Okay. Do you have any changes or additions to your pre-filed direct testimony for these dockets?
No.
If I asked you all of the questions contained in your pre-filed direct testimony from those two dockets here today, would your answers to those questions be the same?
Yes.
Okay. So, Mr. Chairman, I'll move into that the pre-filed direct testimony of Dr. Kim Petrunik in docket numbers 2017-207E and 2017-305E be read into the record as if given orally from the stand.
Dr. Petrunik's pre-filed direct testimony in 2017-207E and 2017-305E will be entered into the record as though given orally from the stand.
Thank you. Dr. Petrunik, did you also attach to your direct testimony in docket numbers 2017-207E and 2017-305E 25 exhibits labeled KP1 through KP3-22?
Yes, I did.
Do you have any changes or additions to these exhibits?
No.
Mr. Chairman, I'll move into the record as the next composite hearing exhibits KP1 through KP3-22 that were attached to Dr. Petrunik's pre-filed direct testimony in docket numbers 2017-207E and 2017-305E.
Those exhibits will be entered as hearing exhibit 146.
Thank you. Dr. Petrunik, did you prepare or cause to be prepared under your supervision 30 pages of rebuttal testimony dated October 24, 2018, which was pre-filed with the Commission in docket number 2017-370E?
Yes.
Do you have any changes or additions to your pre-filed rebuttal testimony?
No.
So if I asked you today all of the questions contained in your pre-filed rebuttal testimony, would your answers to those questions be the same?
Yes.
Mr. Chairman, I'll move that the pre-filed rebuttal testimony of Dr. Petrunik in docket number 2017-370E be read into the record as if given orally from the stand.
Dr. Petrunik's pre-filed rebuttal testimony in 2017-370E will be read into the record as if given orally from the stand.
Thank you. Dr. Petrunik, did you submit with your rebuttal testimony two exhibits labeled KP1 and KP2?
Yes.
Do you have any changes or additions to these exhibits?
No.
So, Mr. Chairman, I'll move into the record as the next composite hearing exhibit numbers KP1 and KP2 that were attached to Dr. Petrunik's pre-filed rebuttal testimony in docket number 2017-370E.
Dr. Petrunik's rebuttal exhibits KP1 and 2 will be entered as exhibit number 147.
Dr. Petrunik, did you also prepare or cause to be prepared under your supervision 3 pages of surrebuttal testimony dated October 29, 2018, which was pre-filed with the Commission in docket numbers 2017-207E and 2017-305E?
Yes.
Do you have any changes or additions to your pre-filed surrebuttal testimony?
No.
If I asked you all the questions contained in your pre-filed surrebuttal testimony, would your answers to those questions be the same?
Yes.
So, Mr. Chairman, I'll move that the pre-filed surrebuttal testimony of Dr. Petrunik be read into the record as if given orally from the stand.
Dr. Petrunik's pre-filed surrebuttal testimony will be entered into the record as though given orally from the stand.
Dr. Petrunik, did you submit with your surrebuttal testimony one exhibit which was labeled KP1?
Yes, I did.
Do you have any changes or additions to that exhibit?
No.
Mr. Chairman, I'll move into the record as the next composite hearing exhibit, Exhibit KP1, that was attached to Dr. Petrunik's pre-filed surrebuttal testimony in docket numbers 2017-207E and 2017-305E.
Exhibit KP1 attached to Dr. Petrunik's pre-filed surrebuttal testimony will be entered into the record as exhibit number 148.
Now, Dr. Petrunik, have you prepared a summary of your testimony in these proceedings?
Yes, I have.
Can you please deliver it?
Good afternoon, Chairman Randolph and members of the Commission. My name is Dr. Kenneth Petrunik. I'm a consultant in the nuclear power industry, and I'm currently a non-executive board member of Horizon Nuclear Power in the United Kingdom. I have a PhD in chemical engineering from the University of Windsor in Canada. I've worked in the nuclear power industry since 1973 and have nearly 45 years of experience in nuclear power and nuclear power plant construction. The primary purpose of my testimony today is to provide the Commission with my conclusions regarding the prudency of SC E&G's oversight of the construction of the Summer Nuclear Unit 2 and 3, which I will call the project, and the sufficiency of SC E&G's disclosures to the Office of Regulatory Staff, ORS, and the Commission. I will also address the testimony of Anthony James, Gary Jones, and Scott Rubin. I have read and analyzed the key reports and documents related to the project, including but not limited to SCE&G quarterly reports to the Commission, monthly reports from Westinghouse, WEC, and its consortium partner, first the Shaw Group and later Chicago Bridge and Iron, or CB&I. Monthly reports prepared by SCE&G's new nuclear development N&D team, direct testimony of SCE&G witnesses in proceedings before the Commission related to the project, direct testimony of ORS witnesses in such proceedings, the resulting Commission orders, legislative reports made by ORS, other documents issued by ORS, and various documents related to or prepared by the Bechtel Corporation. In addition, I have interviewed SCE&G employees and I have visited the project site. It is my opinion that ORS had all the information needed to understand where the project stood and what challenges it faced, specifically as to the completion schedule, but also concerning the other important challenges involved. The monthly reports for this project provided to ORS were quite comprehensive and very detailed. They are standard reports used in managing projects of this sort. They included information concerning milestones, delays, problems, schedule issues, inspection, and critical paths. They ran over 100 pages in length, often, and included a great deal of supporting documentation. They were the basis on which monthly project review meetings were conducted, and the individuals who contributed to them were questioned about what they reflected. To anyone reasonably experienced in nuclear construction, these reports communicated a clear picture of where the project stood month to month and quarter to quarter. They clearly communicated the challenges being faced by the project and the difficulties the project was encountering in meeting the substantial completion date commitments which WEC and CB&I made. SCE&G also produced quarterly reports specifically for ORS which summarized and expanded on the materials provided in the monthly report. These were in turn supplemented by annual construction updates conducted either in formal hearings before the Commission or in allowable ex parte information briefings. ORS also had at its disposal the expert advice necessary to review and understand the information provided and to interpret it for ORS and the public. ORS was advised in these matters by Mr. Gary Jones, whose resume shows him to have had sufficient training and practical experience in nuclear construction to understand the information provided, which was extensive. Mr. Jones' work was supplemented by ORS employees assigned to this project who also had experience in technical and construction matters. It is clear that ORS understood the schedule challenges faced by the project. Turning to Bechtel now, I understand that Bechtel was hired by the law firm that represented SC, E&G, and Santee Cooper to assist those lawyers and project owners better understand the status and potential challenges of the project. Bechtel was asked to conduct a review of the owner's organizational chart and structure, the consortium's organizational chart, the monthly construction progress report, the milestone management schedules, the integrated engineering, procurement, and construction schedules, cost and schedule forecasts, staffing projections, supply chain, and module fabrication information, and other documents. Bechtel was to supplement this documentary review with key consortium personnel, site walkdowns, and interviews with owner's leadership team. I've reviewed the Bechtel reports and schedule assessments. Based on my review, I have reached two primary conclusions regarding the Bechtel report. First, the Bechtel reports do not contain material information that was not previously known to SCE&G and disclosed to ORS. Second, the schedule estimates contained in the Bechtel reports are derived from limited access to the project and are not suitable for SCE&G's commercial considerations in its oversight of WEC. I found no material, undisclosed information, or other surprises in the Bechtel report. The issues raised in the Bechtel reports had been acknowledged and described in detail in quarterly reports to the ORS, the monthly construction report, and other material made available to ORS, and in the testimony and other filings before the Commission. Furthermore, as a general matter, the problems that were identified in the Bechtel reports were generally known in the nuclear construction industry to be problems faced by the two U.S. AP 1000 projects. Members of the industry, myself included, were well aware of the nature of these problems, including the schedule problems. The final Bechtel report was largely outdated before it was issued. Bechtel issued its final report in 2016 based on an analysis conducted in the late summer and fall of 2015. Bechtel formulated its conclusions before the amendment to the engineering, procurement, and construction agreement called the EPC contract. As the Bechtel reports indicate, many of the individual recommendations, by most counts a majority of them, were negated by changes in the consortium structure and other changes made by the 2015 EPC amendment. In late 2015 and prior to signing the 2015 amendment, Flora began to conduct reviews and other initiatives to create new staffing plans, streamline work packages, resolve engineering bottlenecks, formulate mitigation plans, and revise the project construction schedule. A new project management oversight structure was imposed in late 2015, which negated yet another recommendation contained in the Bechtel report. Many of the actions represented recommendations of the Bechtel report that were already in process before the report was issued. The decision not to include that schedule estimate in the final version of the report was entirely logical and supportable. Bechtel was not hired or authorized to generate a proposed schedule for the project, nor was it given access to the information required to do so, as Bechtel itself admits in the report. Given its scope of work under which Bechtel was hired, the limitations under which it operated, Bechtel did not have sufficient information to create an accurate schedule for completion of the project. It was simply impossible for Bechtel to accurately evaluate schedule and milestone delays and to revise and predict future completion dates for the project. There was no reason to give Bechtel the sort of access to data required to create a new project schedule. Bechtel was never authorized to create a new project schedule. In addition, in fact, there is no indication in the documents I reviewed that SCE&G was even aware that Bechtel was preparing an alternative project schedule until one appeared in the presentation materials at the end of Bechtel's work. At the time the final Bechtel report was issued in early 2016, Fluor was engaged in creating a new, fully resource-loaded construction schedule based on access to all relevant data, mitigation plans, and other information. In addition, SCE&G had reached a settlement with WEC in 2015, which was eventually approved by the Commission in 2016, and which transferred substantial risk to WEC in project completion costs and revised completion dates. These dates were from WEC, the vendor, who had all of the project information and, very important commercially, took on these completion risks and dates which were challenging. In other words, they put their money on their words. This was an appropriate schedule to rely on. Also, SCE&G's approach was right in a project management sense. The delayed Bechtel dates were factually unsupported, but acknowledging them as reasonable would have taken pressure off WEC to meet the existing and more challenging schedule commitment. It would have removed the urgency around the existing dates. Turning to SCE&G's role in the project, it was largely defined by the EPC contract, which it entered into with the Westinghouse Consortium, so it could access the AP1000 Advanced Passive Safety Technology. The AP1000 technology was clearly a good choice in light of Westinghouse's experience and standing in the industry and the technology the AP1000 design itself. Another important consideration was that SCE&G was already operating a Westinghouse pressurized water reactor at the Jenkinsville site and had been doing so safely and effectively for approximately 30 years. For a number of reasons, it is best to have comparable reactor designs on a given site. I know the attractiveness of the AP1000 Advanced Passive Safety design from direct experience in competing against it. My former company, AECL, was a competitor of WEC in China. In the end, China chose AP1000 technology over our design and over the existing domestic Chinese reactor designs. I understood why the Chinese selected the WEC AP1000 over other designs. The AP1000 passive safety design is a major advance in the technology, and WEC was a well-respected design firm. The document that I have reviewed showed that SCE&G set a tone and culture of openness and communications in undertaking its role as owner of the project. I fully appreciate the value of this approach, as it is the same model that helped my success in China in completing 2 units ahead of schedule and under budget. SCE&G's approach is quite clear in the documentary record. At every stage of the project, SCE&G appropriately and consistently focused on finding constructive and practical resolutions to issues as they arose. The documentary record also shows that SCE&G understood its role as an owner operating under an EPC contract. Its job was not to be the project manager. Rather, it was to demand performance from the EPC contractors without directing the means or methods used to accomplish the work, or usurping the role of the contractor to manage the work. Under an EPC contract, the choice of means and methods are exclusively the contractor's responsibility. And that was spelled out in the EPC contract. When owners seek to dictate means and methods, the contractor can treat all owners' directives as change orders, and this can dramatically increase the cost of the project and lead to conflict and disputes. SCE&G's actions show that it understood the line between demanding performance and directing means and methods. SCE&G exercised its authority as owner appropriately and effectively. SCE&G wisely adopted a graded approach to oversight of the project. By this I mean that SCE&G calibrated its level of oversight and resources committed on an area-by-area basis to reflect the seriousness of the problems in each area of the project and the risk those problems posed. SCE&G identified in a timely and effective way the areas where problems were emerging that posed a threat to the project and schedule. And then, SCE&G focused its efforts on attention on those areas and enhanced its oversight and commitment of resources to match the difficulty of the problems and the potential consequences, if they were not corrected, as developed. I would also note that SCE&G disclosed those focus areas in its quarterly reports in a timely fashion as they emerge. I successfully used the same graded approach in my oversight role over the Korean APR 1400 unit under construction in Baraka in the UAE. SCE&G also understood the danger of an owner overplaying its hand related to commercial issues. SCE&G quite properly identified its challenge to be that of vigorously enforcing its right under the EPC contract while not destroying the working relationship necessary to successfully complete a project of this scope. SCE&G took constructive action at multiple stages of the project to resolve and mitigate the destructive effects of commercial disputes. SCE&G actively worked to avoid a confrontational culture with the consortium and to promote efficient and effective problem solving as long as it was possible to do so. Adopting a confrontational culture early in the project most certainly would have resulted in higher costs and longer delays. SCE&G was not afraid to push commercial issues, went hard when it saw it had no other alternative for motivating the consortium to solve problems that threatened the successful completion of the unit. I would specifically note SCE&G's action taken in 2014 and 15 to place commercial pressure on the consortium by disputing or refusing to pay millions of dollars of invoices that it asserted were the results of delay, poor productivity, or inefficiency. In taking this action, SCE&G took a calculated risk. Its actions could have caused a breakdown of the project and very nearly did. The consortium threatened in writing to walk off the job in response. But in light of the seriousness of circumstances, taking such risks was justified at that time. It has been my experience that the approach SCE&G took as owner was the most prudent and constructive approach available to an owner under the EPC contract. It is my opinion that SCE&G discharged its function as an owner with insight and care. This concludes the summary of my direct testimony. The summary of my rebuttal testimony is very short. I will respond to the contentions made by Mr. James, Mr. Jones, and Mr. Rubin regarding SCE&G's retention of Bechtel and SCE&G's disclosure of Bechtel's recommendations and schedule estimate. I will address contentions regarding SCE&G's oversight and management of the project. I will also address Mr. James' assertion that SCE&G utilized a hands-off management style which was imprudent, and Mr. Jones' contention that the schedules provided to ORS and throughout the project were insufficient and demonstrate imprudent management of the project. Finally, I will address Mr. Rubin's contention that a prudent owner would have abandoned the project in 2013 or 2014. Mr. James and Mr. Jones are simply incorrect when they assert that SCE&G withheld material information from the Commission and ORS, and that it was imprudent not to disclose the retention of Bechtel or Bechtel's limited findings and conclusions. Disclosure of Bechtel's limited findings and conclusions would have not changed the overall assessment of the value of continuing the project. In addition, as I explained in my direct testimony, the construction scheduled in the Bechtel report was based on inadequate information, did not reflect key project data, and was based on assessment work performed by Bechtel before the EPC amendment. It is properly excluded from the final Bechtel report. The decision not to include Bechtel's schedule estimate in the final version of the report and not to present that schedule estimate was entirely logical and supportable. Bechtel was not hired or authorized to generate a proposed schedule for the project, nor was it given access to the information required to do so, as Bechtel itself admits in the report. Turning now to Mr. Jones' criticism of the SCE&G's management style, Mr. Jones failed to recognize that adopting a confrontational culture early in the project most certainly would have resulted in higher costs and longer delays. He is simply incorrect when he asserts that applying more pressure on the consortium would have achieved improvements in production rates and productivity levels for the project. It has been my experience over many such projects that the approach SCE&G took as owner was the most prudent and constructive approach available to an owner under the EPC contract. It is my opinion that SCE&G discharged its function as an owner with great insight and care. Turning now to Mr. Rubin's contentions regarding abandonment of the project, I do not agree that the project should have been abandoned in 2013 or 2014. The AP1000 technology is sound and could have been completed as evidenced by completion of the reference AP1000 units in China. The international new build AP1000 program is moving ahead. AP1000 units at Sanmen and Haiyan in China are now in service, and added AP1000 units are being actively considered in China, indicating that the Chinese are satisfied with final performance and output. The project and companion AP1000 Vogel project were premised on following the Chinese lead and a program which is now actively moving ahead. China has shown that completion of the AP1000 is achievable. I would not have recommended abandonment in 2013 or 2014. I'd like to address one last point. I understand that South Carolina legislation now allows for an owner, such as SCE&G, to be held responsible for the imprudent actions of contractors, subcontractors, or vendors, even if those are not contractually assigned to the owner. I've never seen a situation where an owner is accountable in this way. It makes no sense. Construction of nuclear construction projects would cease if this were the norm. The South Carolina legislation transfers all project risk from the vendor contractor to the owners. No reasonable owner would take on a project if it must assume all the risk for the project. The risk structure created by this legislation cannot work in the real world. I've never seen a project that operates under such a structure. This concludes the summary of my testimony.
Thank you, Dr. Petrunik. Mr. Chairman, these witnesses are available for questions from the commissioners and cross-examination by the parties.
Okay, we'll begin cross-examination in about 10 minutes. We're going to take a short break.